But by and large, that would be a huge dilemma. A huge dilemma.
Yeah.
But without speculating what the judge would do, if I'm the lawyer who is arguing that matter,
Mm-hmm.
I would just simply say these are the wishes of the deceased.
Yes.
This
We'll
man
go
could
for it.
have given the property to the church, and the church would not have proved DNA.
Yes.
He could have given property to his best friend, and they
Yes.
would not have
Proven
proved
DNA.
DNA.
Yeah.
He could have given the property to his youngest sibling, whom he raised, and he considers him a son instead of a brother.
Yes.
So, it you would have to come up with technicalities on how to navigate that kind of situation.
Yeah.
Yes.
That's amazing. I hope, guys, you're learning. And these are things we're talking about that are in our communities. These are things that are out in your neighborhood. In Uganda, they're so popular and so common. And I'm here that to give you this knowledge. Guys, keep on, listen, but please do us a favor and share this content. Once again, we'd like to appreciate Naria Motel, where we do our podcast from. We appreciate this place, and please take time and visit this place whenever you're free. So now, can a man make a will and let the wife be the custodian of his will? I may be there, I don't have anybody I trust, but I trust my wife. And I've made my will, and I want my wife, because I trust her, believe in her, to make sure that she's the custodian of my will. That even when I'm making a will, my wife is aware of what I've put in the will, and she becomes the custodian of this will.
Okay, so this is an action-packed question. So we need to actually know
Yes.
what the law requires to be done when it comes to drafting a will.
Yes.
First of all, under the new law, the will must be in writing.
Yes.
There has always been a notion in the subject of wills that it, the testator, when they make their will, that will must be attested to or
Yeah.
must be witnessed.
Yeah.
The witnesses can never be beneficiaries in the will.
Yeah.
So if you get your wife to witness
Uh-huh.
and she's supposed to be a beneficiary,
Yeah.
that's a ground for invalidating the will.
Yeah.
Your children should not attest to
Yeah.
the will. But even the people who attest or witness the will, they never read the content.
Yes.
They don't.
Yeah.
Because probably they would go and say, hey, by the way, do you know if your father dies, you're going to get that house and your brother will only get 2 goats?
Yes.
So to avoid all that, the process how the will is made is that a will is a secret by and large.
Yeah.
It should only be opened at the time of reading it and trying to implement it.
Yeah.
But let's assume you come to me.
Yeah.
You tell me if you're not draft for me a will. Once I draft it, you know what you've told me.
Yeah.
I know what you've told me.
Yeah.
Now you bring 3 people who are going to
Witness.
witness, but we call it attesting.
Yeah.
The new law requires that they write their name on each and every page of the will. As they write, we cover the contents.
They shouldn't see the content.
They should not see the
And
contents.
yet they are the ones who are going to keep copies.
Yes. Why? Because you see how they are trusting that once they put it in the envelope, they seal it.
Yes.
Your job is to keep it in the safe. You only open it when that man has died.
I can open the envelope and seal it again.
No.
Yeah. I can open the envelope and seal again the same envelope.
You see,
Yes.
that is because you're not a trustworthy person.
Yes.
But people who are keeping other people's wills, they
No, I may be trusted, but I want to say yes,
no,
and I will say it. But and I think so.